There have been studies, as I mentioned, the Law Commission, that it's quite onerous. You know, when someone becomes subject to the guardianship order, it's everything. Like, you might be capable of managing your day-to-day banking, but the Office of the Public Guardian, or whoever takes on the role, really has control. So it's a pretty awesome power. And so the first step, and the most often used, about 3/4 of guardianships come by way of a statutory guardianship. And what that means is that the Office of the Public Guardian and Trustee take the guardianship of the person after the person has been assessed as incapable. So it starts with an assessment. And that assessment could take place in a couple of different ways. If the person is in a psychiatric facility, hospital, a doctor can assess the person as incapable of managing their property. Then the PGT will become the statutory guardian. If the person is just in the community, at home, or whatever, then they can be assessed by an independent assessor, usually from the Capacity Assessment Office, who I'll talk about a little bit later, but they have a roster of designated and trained assessors who can make the determination. And if that has been presented to the public guardian and trustee, the public guardian and trustee will take over. And at that point, the family member can apply to take it over from the public guardian and trustee. And there's an application form. It's not necessarily that quick a process, though. I've heard it can take several months. And there is a fee as well, I believe about almost $400. So what happens in a capacity assessment? Some of you may have attended these, but it's really to understand whether the person has a factually accurate understanding of events. So if it's finances, they should be able to identify how much money they're bringing in, what their debts are, any other financial involvements. And the assessor will give the person some information and see if that person can retain it or interpret it, use it, just to see if they really understand the information. The point is not whether this person is really a financial whiz, but and it could be that the person likes to spend their money on things that aren't particularly usual, or they may not be spending their money in their best interests. Maybe they're playing the lotto too much. But I mean, as long as if they still can appreciate the consequences of their choices, then it's up to them. It doesn't necessarily mean they're incapable. So the assessor has to figure out if they can function fairly normally, they can reason and process information. That's the basis of it. And then if a person has been assessed as incapable, whether they're is in a hospital or by an assessor, they have the right to go before the Consent and Capacity Board and ask for a review, and they can have it overturned. And that happens all the time. The board can supply the person with counsel to do that. So in terms of replacing the PGT as guardian, we have a number of those issues come up on the Pro Bono Ontario hotline, and again, it does involve an application. You could be the person's attorney, you could be the spouse, the partner, relative, but you have to be a family member. If you're a person outside of that, you may have to apply to court. You can't necessarily go this route. That leads us to the court-appointed side of things. So, as I said, the statutory guardianship is the quickest way and the easier way to get a guardianship if a power of attorney is not an option. And it may not be if the person you're looking after isn't capable of making a power of attorney. And that happens. Sometimes it's just too late to make a power of attorney. And it also comes up when people are looking after their children with disabilities. They may have done everything for the child and made all the decisions and been the spokesperson, and then the child becomes 18 and suddenly nobody wants to talk to the parent because they don't have the legal authority. You just don't automatically get to continue making those decisions. And the way the government works now, especially, is that you have to either have, if you can't get a power of attorney, you have to have guardianship. So sometimes you have to go to court for it, and it could be in a situation where the person has refused to undergo an assessment, but really is in need of guardianship. Or if there's been some kind of mismanagement by the attorney or the existing guardian. That's where you would go to court. And unfortunately, the court process is expensive, it's time consuming, you need a lawyer. It's obviously the power of attorney route is the easiest, and the next is the statutory. This is the most difficult. The court must be satisfied that that guardianship is the only way to have this person's needs met. If there's some alternative way to help this person, they won't appoint a guardian. So they have to find that the person's incapable of managing the property and there's no other way of doing it. There's no less restrictive way. This is one of the areas that, again, that the Law Foundation is recommending be looked at to make it a little more flexible and maybe be able to let the person preserve some independence and autonomy past the point of the guardian. Having, for instance, somebody appointed in a support role, because the guardian really becomes the decision maker for sure. I just want to talk a little bit about the Public Guardian and Trustee's Office in case you aren't familiar with what they do. They have a wide range of things they do. They have to review all the applications for not only statutory but also court-appointed guardianship. When you apply to become the guardian, you have to submit a management plan, like an outline of steps you're going to take to manage the person's property. So they have to review and approve all of those. And they can work with the court to review accounts that you've kept, or to remove or replace an attorney or a guardian. And they also keep a register of all the guardians appointed in Ontario. And as I mentioned, there are thousands of people under guardianship, but they're also supervising as well. Another thing the Public Guardian and Trustee's Office does is guardianship investigations. So if you are concerned about a loved one who perhaps isn't amenable to your helping them, or you're worried about how they're being treated by whoever is looking after them, you can ask the PGT to investigate. And the baseline is that they have to be suffering or at risk of serious harm as a result of whatever situation they're in. There's a fee for this service, but sometimes it's the only way of making sure that someone isn't being exploited, either financially or at some kind of physical harm. So it could be that the PGT might require a warrant if they're not allowed into a home, but they will investigate, and then they will take steps to assist the incapable person, either by making sure that like the bank account is frozen, or applying to court to become the guardian. So sometimes you might have a loved one who is seriously in need of assistance, is just not having it, isn't interested in an assessment. You may have to go this route to get some help for that person. Okay, so I just wanted to, before I take some questions, just to remind you that the Pro Bono Ontario has this hotline that you can call if you have any questions. Even though it says press 6 for powers of attorney, and it's Mondays and Wednesday mornings they answer these questions. You can ask about estate administration, about wills, for instance, and so on. They don't do wills, but you can also get referrals. Before I started, I was told that you might be interested in the cost of getting these documents prepared by a lawyer. And as in my experience, on the Pro Bono hotline, we usually advise people to either call the Law Society of Ontario, who has a referral service, and you can get connected with a lawyer who will give you 30 minutes free consultation if you have a particular issue. There's also an organization called JusticeNet, which charges on the basis of a sliding scale, so it's a lot less money for people, and the lawyers in their network will charge based on income. The other kind of easy way, if you have the money, is to go to Access Law. The government even recommends this. It's the law office run by the Walmart stores. It's in most of the Walmart stores, and they often offer specials, so you can get a will and 2 powers of attorney for $250 or something, or $299. It's a fairly reasonable rate. You can also just get powers of attorney. I think it's like $159. The only thing is, I've heard. My sister-in-law went to one of these on my advice, and it turns out they use a template. So if you have a kind of a slightly complicated set of beneficiaries or way of dividing, it might not fit into their template, and they might tell you they can't do it, or they have to adjust it somehow. So just to be warned that it should be a fairly simple will if you go there. If you go to just a regular lawyer, like not a big firm lawyer, but a sole practitioner, it could cost you anywhere, if you're an individual, between $300 to $500, or up to $700 maybe. It depends on your estate. If there's two of you, maybe for the two of you, it could be $1,000 or $1,200. So that's the general picture. Here at Bridgepoint, we help patients for free. So. Anyway, just to be aware of the Pro Bono Free Legal Advice Hotline, there is a income eligibility, but they will always answer your first question if you call, if you exceed, and there's a range of income that they ask you about depending on how many people in the household. And if you're asking for someone who is, maybe you have means, but the person you're asking about doesn't, then you can ask based on that person's income. And we also get calls from not just family members, but social workers, other professionals asking for help for people who don't have the money and need the help. So if you know anybody in that situation, that's something you can advise. And as I said, we have brochures at the back that you can take a look at.